Welcome back and good afternoon to you. Some people immigrate to the United States alone, but most people immigrate with their families. What are the rights for your spouse and your children? Today, we're going to talk about how naturalization impacts families. First, let's talk about green cards through marriage. Let's say your spouse was a permanent resident when you were approved for your green card. In that case, you and your children must wait 5 years before you can apply for citizenship. However, if your spouse was already a U.S. citizen when you were approved, and you can prove that you're still living together 3 years later, you and your children may apply for citizenship at that point. That's a little confusing, so let me break it down. If your spouse is already a U.S. citizen on the day you're approved for your green card, and you can prove that you're living together for the next 3 years, you and your children can apply for citizenship then. If your spouse is a permanent resident, you and your children must wait 5 years to apply for citizenship. Now, let's talk about children. When your children are under the age of 21, their status automatically matches yours. If you enter with a temporary visa, they are permitted to be in the United States exactly as long as you are. When you apply for your own green card, you apply for their green cards also. And most importantly, for those children under the age of 18, when you become a U.S. citizen, so do your children. We've talked before about the Child Citizenship Act of 2000. This historic amendment to the Immigration and Naturalization Act of 1965 was created to ensure that families stay together. It doesn't matter if your children were born in another country, if they're your biological children, or if they're adopted. The day you become a citizen, they do too. If you are new here, make sure you click that subscribe button and check out the links below. Thank you for the privilege of your time. We'll see you next time.